People versus Eric Hoover, file number 256840.
People, on behalf of Mr. Hoover.
The record should reflect Mr. Hoover is present here in the courtroom today. This is the date and time set for sentencing in this matter. Mr. Hoover, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, Your Honor.
Okay. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your
Honor. Mr. Rolla, do the people have any additions, deletions, or corrections?
Judge, there is one situation on there. I see that actually it's under the recommendation for sentencing. I believe the fee for the drug blood testing is $200, not $250.
$200. Okay.
Correct, Judge.
Okay.
But other than that, no other corrections. Thank you.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Yes, Judge. This is the first felony, but the defendant has indicated by his record is a long-time alcoholic. His first drunk driving conviction was back on March 3rd, 1986. This is his sixth drunk driving. His BAC in this case was only a .106 by blood, but that was taken sometime later. In any case, it doesn't really matter. This person's had a long time history of driving while intoxicated, and still apparently is either unable or unwilling to address that situation without placing the public in danger. There's a recommendation in this case of 30 days and 5 days credit. That's mandatory minimums. As the third, I think in light of the circumstances, especially since we're also dealing with a resistant obstruction charge, and as well as a misdemeanor driving license suspended, some jail time support. Thank you.
I guess I want to ask you one question about your allocution. And maybe I heard wrong. Did you say, because I counted 2 priors, I thought you said 6 priors.
This is Mr. Did I say this? This is Mr. Hoover, is it not?
Yes.
That's what I thought, Judge. 6 drunk driving since 3/3/86. I can go through all of those with the court if you'd like.
I'm looking at the PSI, the adult history of the PSI. 1 of 4 is his first offense in 1989 of operating while under the influence. I have another one in 2006, which is number 2 of 4, and then this one.
But actually, it didn't account for his ones back on 3/3/86 as well as Judge. It shows up in the lien that we have.
Okay.
This was working a little slow. Genesee County 67th District Court on March 3rd, 1986. Then Flint on March 28th, 1999. OWI 2nd. Then the 71A District Court in Lapeer on June 1st, 1991. Then we have an impaired in Kalkaska in the 87B District Court on January 10th, 2007. And impaired in the 87B District Court in Kalkaska 12/15/16, and then the ignition interlock, which was a violation for alcohol as well, Judge, and that's what I.
Okay. Mr. DeLeo, do you know why those wouldn't have been?
I'm looking at the copy of the lien I was provided to do the report, Your Honor, and I can't explain why, but ours does not have the rest of the convictions.
All right. Okay. Thank you. Mr. Brown, anything on behalf of Mr. Hoover?
We have just 1 minute.
Madam Coach.
Yes.
I can't remember if I sent these.
Mr. Brown, anything on behalf of Mr. Hoover today?
Yes, Your Honor, thank you. I just handed the court some letters from the VA. He is currently in treatment, working with Trisha Myers, who's actually here today to help support him. I guess I am at a little bit of a disadvantage. I was a little confused to hear about the many priors as well, because I'm going off the same PSI that everybody has. And I'm showing and operating under the influence, not just the final charges, but also the charge at arrest. So this wasn't an OWI that was let down. And that was back in 1989, and another OWI in 2006, which were about 18 years apart, I believe, 17, 18 years apart. And other than the instant matter here, its most recent prior was almost 20 years ago.
Well, I mean, obviously, Mr. Hoover was supposed to be operating a vehicle equipped with an interlock device at the time of this offense. So there had to have something had to have happened in the intervening time to bring about that requirement.
Mr. Hoover, again, is currently getting treatment. He is taking psychiatric medication. I know he has some mental health issues that he is dealing with. He currently has a girlfriend, a significant other that he is living with, just recently had a stroke. He is basically caring for her. She's bedridden, 24-hour-a-day, around-the-clock care. He essentially, at least states to me, that he was sober for many, many years. The stress of being disabled, which he is currently on disability, around-the-clock care for his girlfriend, somebody that he's been with for quite a while and truly cares about, and just the stresses of those things. Unfortunately, a lot of times people look to things to deal with those stressors and triggers and things other than getting perhaps a more or a better kind of help, or beneficial type of help. They turn to alcohol, which is a temporary relief, but it does cause a lot of problems, which Mr. Hoover does know that. This was a very bad decision on his part. I think he understands that. Ask the court to take all that into consideration. The resisting arrest, again, those are things that quite commonly go along with intoxication or being under the influence of something. And we often see those charges together whenever the police are called. He is working on this. It is not something that he wants to define him. Again, he does have a relationship with Ms. Myers in a professional setting. She is here today to support him. So she sees something there that can be salvaged. He is not just an alcoholic. So I would ask the court to take all those things into consideration. I realize that there is a statutory minimum, and I would ask the court to adopt the recommendation.
Thank you. Mr. Hoover, anything you wanted to say today?
Yes, Your Honor. Not really sure where you want me to start. I was introduced to alcohol when I was in the Army. I was at a physical security base. Didn't have anything to do but our job and drink. It's isolated depot, wasn't even a base. And it started from there. I got out, ran into problems, was trying to take care of those issues. I've been trying to take care of those issues. I was sober for, what's going on 18 years. I battled stage 4 cancer without turning to alcohol. I cared for my parents, watched them pass in front of me, didn't turn to alcohol. I was trying to get, I was doing good. I was working with the courts and with everybody to get my license back. I brought it to the court here in front of Judge Hunter. Had the interlocking device put in. Then they changed I only had a couple months to go, and they changed the rule that circuit court couldn't override the ruling of the Secretary of State's office. Had to start all over. Okay.
Well, that took a turn. We just sat through the sentencing of Eric Hoover, and there's a lot to unpack here. Judge George Mertz ran this one with his usual composed presence measured, methodical, and clearly weighing every bit of information. The hearing started off as standard fare. Mr. Hoover had reviewed the pre-sentence report with his attorney. Mr. Brown and both sides had minor corrections, mostly clerical, but once the prosecutor launched into allocution, we found ourselves in unexpectedly deep waters. According to the prosecution, Mr. Hoover has a long and troubling history with alcohol-related offenses. 6 drunk driving, convictions dating all the way back to 1986. That revelation caught just about everyone off guard, including Mr. Brown, who was working from a report that only showed 2 prior convictions. Judge Mertz sought clarification and received a breakdown of multiple entries across different jurisdictions, including Genesee, Flint, and Delta Township. It became pretty clear this wasn't just a technical mix-up. It was a major discrepancy with real weight. Mr. Brown, to his credit, didn't flinch. He pivoted quickly and presented a thoughtful argument that centered not on denial, but on context. He highlighted Mr. Hoover's ongoing treatment, his connection with the VA, and the support of his counselor. Ms. Myers, who was actually present in court, Mr. Hoover, we learned, is also a full-time caregiver for his partner, who recently suffered a stroke and requires 24/7 care. Brown painted a portrait of a man buckling under stress, grappling with mental health issues, and turning to alcohol after a long period of sobriety. And to be fair, Hoover's own statement hit on those same notes. He spoke candidly about his history, including battling stage 4 cancer and enduring major personal loss without relapsing. According to him, this recent offense marked a setback, not a lifestyle. It was heartfelt, not rehearsed. But sincerity aside, the facts weren't on his side. Hoover was supposed to be driving with an ignition interlock device, and the resisting arrest charge only deepened the court's concerns. The tension in the courtroom wasn't loud, but it was palpable. This was one of those moments where everyone involved, the judge, the attorneys, even the defendant, seemed to understand that the case was sitting on a knife's edge. Judge Mertz didn't jump to conclusions. He asked questions, clarified records, and took in a surprising amount of new information right there on the bench. You could tell he was working hard to balance empathy with public safety, especially in light of Mr. Hoover's extensive and underreported history. The final sentence isn't detailed in the record here, but if I had to guess based on Mertz's measured tone, he probably landed somewhere between compassion and accountability, something that reflects the gravity of the offense without ignoring the human side of the story. This hearing was a prime example of why courtroom nuance matters. Not every case is cut and dry, and not every defendant fits neatly into a box. Mr. Hoover's history, both personal and criminal, made this one a challenge. The courtroom remained calm, even as the facts got complicated. And Judge Mertz, as always, steered the ship steadily through it all. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.